My husband had been dead for 12 days when a judge called my Navy Cross worthless. I stood beside Rachel Monroe in my service dress uniform. I had come directly from a memorial ceremony at the naval station. There had been no time to change. Across the courtroom, my father-in-law watched me with open contempt. Harold Foster had sued for control of the company Michael and I had spent years protecting. His attorney, Peter Lang, pointed toward my uniform. Commander Foster is attempting to influence the court through military symbolism. Judge Malcolm Vance looked at the medal above my left pocket. His expression carried no curiosity, only disdain. That medal is worthless in my courtroom, he said. Harold laughed. The sound was quiet, but everyone heard it. People turned toward me. The clerk stopped typing for half a second. I did not touch the medal. It had been awarded after an evacuation operation that brought sailors and civilian contractors out of an active attack zone. It was not costume jewelry. It was not a campaign prop, and I had not worn it for Judge Vance. Rachel stood. Your Honor, Commander Foster is wearing an authorized uniform. We ask that the court preserve your exact statement in the transcript. Judge Vance leaned forward. This courtroom will not become a stage for military theater. I remained silent. Then I opened Michael's old leather case and removed his work phone. Rachel had already disclosed the device, the audio file, the carrier verification, and the forensic report. She placed the phone on the evidence table. We moved to admit a voicemail relevant to the court's impartiality and the pending motion to recuse. Peter rose immediately. This is an ambush. No, Rachel said. Your office received the file 4 days ago. Judge Vance looked at the phone. You will not play unauthorized recordings in my courtroom. Rachel did not raise her voice. The recording contains your voice, Your Honor. The room changed. Harold stopped smiling. Judge Vance told Rachel the file had no foundation. She presented the carrier record, then the forensic copy, then the affidavit establishing that Michael had received the voicemail on his company phone before his death. Judge Vance looked toward Peter. Peter looked down. Rachel nodded to me. I pressed play. For several seconds, there was only the sound of movement inside an office. Then Peter's voice came through the speaker. She will wear the uniform. Another man answered. Judge Vance. Good. Make the medal look like theater. No one moved. The recording continued. Once the room sees her as a soldier performing for sympathy, the ownership records will not matter as much. Judge Vance struck the bench with his hand. Turn that off. I stopped the file. Rachel looked at the court reporter. Please preserve the order to stop the recording. Harold stared at the phone as though it had become something alive. The part we had played was not the end of the conversation. The next section named the receiver Judge Vance intended to appoint. It had been recorded weeks before Michael died. And weeks before Harold ever filed the lawsuit, Michael collapsed inside the conference room at Foster Maritime Supply. I was at the naval station when his operations director called me. By the time I reached the hospital, my husband was gone. A nurse handed me his wedding ring, wallet, keys, and work phone inside a clear plastic bag. I had not yet understood the word widow when Harold arrived. He looked through the glass at his son. Then he asked who had the company stock ledger. His next question was about Michael's trust, then the warehouse keys, then the authority to sign customer contracts. I stared at him. Your son just died. Harold's jaw tightened. Foster Maritime cannot be left without leadership. Michael had been dead for less than an hour. Harold was already planning his return. At the funeral, he introduced himself to several employees as the company's founder. He told them he would stabilize the business. He never asked whether I intended to remain involved. He assumed I would return to the Navy and disappear. 3 days later, Peter Lang served me with the petition. Harold claimed the sale of his company shares to Michael had never been completed. He asked the court to freeze Michael's trust. He wanted my voting rights suspended. He wanted a temporary receiver placed over Foster Maritime. He also wanted me prohibited from changing contracts, moving funds, or selling company property. The petition described me as an absentee military spouse with no meaningful knowledge of civilian business. Peter attached my deployment history, dates I had served overseas, dates I had attended naval logistics exercises, dates I had spent away from Michael. They used my service as proof that I did not belong inside the company. Rachel did not begin by answering the insults. She examined Harold's finances. The reason for his urgency appeared in the records of a failed marina development. Harold had borrowed heavily to build luxury slips, restaurants, and private waterfront residences. Construction costs rose. Investors withdrew. The project stalled. His lenders were demanding payment. He had less than 60 days before they could pursue his remaining assets. Then Rachel found a letter of intent from Harbor Ridge Capital. Harold had promised to deliver Foster Maritime's main warehouse, port access rights, and operating contracts if he regained control. The warehouse was worth far more than the amount Harbor Ridge offered. The agreement would rescue Harold's debt while stripping the company of its most valuable property. It had been signed before Michael died. Harold had not reacted to a sudden family tragedy. He had prepared to use it. A success fee appeared near the end of the agreement. Part of it would go to Peter. Another part would be paid to a consulting company connected to Harbor Ridge. Rachel searched the corporate registration. The company belonged to Judge Vance's brother. Harold had filed his lawsuit in a courtroom where the judge's own family could profit from the result. Harold had founded Foster Maritime more than 30 years earlier. That fact was true. The rest of his story depended on pretending nothing had happened afterward. 10 years before Michael died, Harold needed money for the marina project. Michael agreed to buy most of his father's shares. It was not a handshake between family members. Harold had his own attorney. The agreement listed the purchase price, payment schedule, voting rights, management authority, and transfer of shares. It required Harold to leave the board. It also stated that once the final payment cleared, he would hold no controlling interest in Foster Maritime. Michael made every payment. Harold signed the stock transfer. The company ledger was updated. His tax return reported the money as proceeds from the sale of a business interest. Years later, he used the same agreement in a loan application. He swore to the bank that he no longer controlled Foster Maritime. That statement helped him obtain millions for the marina project. Now he wanted a different court to believe the sale had never happened. Rachel placed the records in chronological order. The contract, the payment confirmations, the stock certificates, the board minutes, the tax return, the loan application. Each document supported the next. But Harold's loss of control was only half the story. 5 years after the sale, Foster Maritime lost a major defense supply contract. Revenue dropped. The bank threatened to cancel the company's credit line. Without new capital, the warehouse could have been seized. More than 60 employees could have lost their jobs. I used my personal savings, then my deployment pay, then part of an investment account I had built before marrying Michael. The money entered Foster Maritime through a documented capital contribution. The board approved the transaction. I received equity in return. The company's tax records reflected it. The infusion kept the warehouse open and allowed Michael to negotiate new contracts. Harold now called that money a family loan. He claimed I had never been a real owner. Rachel found an email he had sent Michael during the crisis. Danielle did what no bank would do. She became a real equity partner when the family needed her. Harold had written those words himself. He also submitted a capitalization table carrying my name when he applied for additional financing. At that time, my ownership made the company look stronger. Now it stood between him and the warehouse. His petition required the court to believe 3 incompatible stories: that he had never sold control, that Michael alone owned the company, and that my documented equity was only temporary assistance. Rachel closed the final loan file. To win this case, she said, Harold has to deny the same records that helped him borrow millions. Then she opened Judge Vance's financial disclosure. There was no mention of Harbor Ridge, no mention of his brother's consulting company, and no explanation for why the receiver named in Michael's recording had already been selected. At first, I believed Judge Vance's hostility toward me was personal. Some people saw a uniform and assumed obedience without intelligence. Others saw a medal and imagined vanity. Judge Vance seemed to believe both. He called me the naval widow instead of Commander Foster. He described my service dress as theater. He allowed Peter Lang to use my deployments as proof that I had been absent from my marriage and disconnected from Foster Maritime. But prejudice alone did not explain every ruling. Rachel began reviewing Judge Vance's public disclosures. A judge was required to identify financial interests and relationships that could raise reasonable questions about impartiality. His forms did not mention Harold. They did not mention Peter. They did not mention Harbor Ridge Capital. And they did not mention the consulting company owned by his brother. I remembered meeting Judge Vance at one of Harold's private club dinners several years earlier. Harold had introduced him as an old friend of the waterfront business community. Rachel found photographs from other events. Judge Vance stood beside Harold at a marina fundraiser. Peter sat at their table during a charity dinner. The president of Harbor Ridge appeared in photographs with the judge's brother. None of those images proved corruption. Judges, attorneys, and business owners often attended the same public events. But Judge Vance's rulings created a different kind of pattern. He accepted Harold's affidavit almost immediately. He delayed the company's stock ledger because Peter questioned its authentication. He restricted discovery into Harbor Ridge's offer. He allowed Peter access to selected trust records while refusing Rachel's request for communications surrounding the proposed warehouse sale. Whenever Rachel challenged the unequal standards, Judge Vance accused her of wasting time. She requested every ruling in writing. She asked that every remark be preserved in the transcript. His irritation increased each time she did. Then Rachel obtained the consulting agreement between Harbor Ridge and the company owned by Judge Vance's brother. The original agreement provided a fixed monthly payment. A revised version had been signed 3 days before Harold filed his lawsuit. The new agreement promised a much larger fee if Harbor Ridge acquired Foster Maritime's warehouse and port access. Judge Vance's family could profit if his rulings helped Harold gain control. That interest appeared nowhere in his disclosures. The invoice described the service as judicial and regulatory access strategy. Rachel placed the document beside the court orders. "We do not have to claim the judge received money," she said. "We only have to establish that his family had a financial interest he failed to disclose." His brother's payment depended on a transaction Judge Vance was moving steadily toward approval, and the contract selling access had been rewritten before the lawsuit officially existed. Michael's old work phone contained more than the recording we played in court. Before opening the remaining files, Rachel gave the device to a forensic technician. He created an exact copy and preserved the original. The voicemail carrying Judge Vance's voice had arrived 6 weeks before Michael died. Carrier records showed it had been forwarded from Peter Lang's office telephone. Michael had spoken with Peter that afternoon. Peter called it a family settlement discussion. He proposed that Michael return control of Foster Maritime to Harold and persuade me to surrender my voting rights. Michael refused. The call appeared to end. But Peter did not disconnect correctly. His office voicemail system continued recording after he placed the receiver down. The first voice in the room belonged to Peter. "He will not agree while she believes those shares protect her." Harold answered, "She is never home. Use that." Then another man spoke. Judge Vance. "Absence will not be enough." There was a brief silence. Then he continued. "She will wear the uniform. She always does when the Navy is involved." Peter asked how that would help them. Judge Vance replied, "Make the medal look like theater. Once the room sees her as a soldier performing for sympathy, the ownership records will not matter as much." That was the section the courtroom had already heard, but the recording continued. Peter asked who could control the company while the ownership dispute was pending. Judge Vance supplied a name, Grant Mercer. He said Mercer could stabilize Foster Maritime, examine the contracts, and prepare the warehouse for a possible transaction. Harold asked how quickly the sale could be completed. Judge Vance answered, "Once she loses credibility, Harold gets the company, and Mercer gets the keys." They discussed describing my investment as temporary family assistance. They discussed portraying my deployments as abandonment. They discussed requesting a receiver before the court fully examined the ownership records. The voicemail ended several minutes later. Michael had not relied on the audio alone. He sent a copy to an independent judicial ethics attorney. The attorney obtained the carrier records and documented the source, date, destination, and receiving device. Michael also left a letter for me. He apologized for hiding what he had discovered. I had been preparing for an important assignment, and he feared Harold would attack my military career if I became involved too soon. He believed he could protect me by handling the problem privately. Instead, he excluded me from a danger that involved my money, my reputation, and my future. Michael instructed Rachel not to release the recording simply because Harold threatened him. Several things had to occur first. Harold had to file the lawsuit. Judge Vance had to receive the case. He had to refuse to withdraw. And he had to use my military service to weaken my credibility. Michael did not want the recording to predict wrongdoing. He wanted Judge Vance's own conduct to confirm it. When Vance called my Navy Cross worthless, he completed the pattern himself. His words had not been spontaneous. They had been rehearsed. And the receiver named in the recording was already waiting to take control of Michael's company. Rachel warned me not to confuse a powerful recording with a complete legal victory. "The audio proves what they discussed," she said. "It does not automatically decide who owns the company." Before using it, she had preserved the original phone. A forensic copy had been created. The carrier had confirmed when the voicemail arrived, which office line sent it, and which device received it. An audio specialist had examined the file for cuts, inserted speech, or altered timing. The full recording and transcript had been provided to Peter before the hearing. Rachel had also notified the State Judicial Conduct Commission. There was no courtroom ambush. Peter still called the audio fraudulent. He claimed someone had assembled separate conversations to imitate a secret meeting. The audio specialist found no evidence of editing. The background sound remained continuous. The room acoustics did not change. The system timestamps matched the carrier log. Peter then claimed the voices had been misidentified. Rachel produced earlier recorded hearings and public speeches containing Judge Vance's voice. The comparison did not require guesswork. Judge Vance changed his defense. He said the conversation was only a hypothetical discussion among acquaintances. Rachel asked why a sitting judge had discussed a receiver by name before a lawsuit had been filed. Vance said lawyers frequently discussed possible cases. She asked why he had accepted Harold's case after participating in that discussion. He refused to answer. Rachel formally moved for his recusal. Judge Vance denied the motion from the bench. He said the recording had been taken out of context and that no reasonable person could question his impartiality. Then he accused me of using a military decoration to pressure the court. He threatened to hold me in contempt for playing a phone inside the courtroom. Rachel reminded him that the device had been marked as an exhibit and played only after a formal request. She asked that his threat be preserved in the transcript. The more Judge Vance tried to erase the meaning of the audio, the more decisions he added to the official record. He continued restricting discovery into Harbor Ridge. He refused to examine his brother's consulting agreement, and he scheduled a hearing on Harold's request for a receiver. After court, Judge Vance returned to his private office. Less than 10 minutes later, he called Peter Lang. We did not know what they said. But Michael's ethics attorney had already requested a preservation order covering courthouse telephone and communication records. The call could not quietly disappear. Its time, duration, and destination were now part of the investigation. And the next morning, Judge Vance appointed the exact receiver named in Michael's recording. The morning after Judge Vance's call to Peter, Harold filed a new affidavit. It did not focus on stock certificates or payments. It focused on me. He said I had used my military reputation to control Michael. He described my deployments as abandonment. He claimed I knew nothing about the daily operations of Foster Maritime. According to Harold, my investment had never made me an owner. It was only money I used to make Michael dependent on me. He even mentioned the Navy Cross. He called it a symbol I displayed whenever I wanted people to stop questioning me. Peter submitted photographs from my assignments. One showed me boarding a transport aircraft. Another showed me at a logistics conference overseas. He presented every day I had served away from home as evidence that I could not possibly understand the company. Harold asked Judge Vance to appoint a receiver. The receiver would control the accounts, contracts, warehouse, and customer records while the lawsuit continued. Rachel objected. She reminded the court that the man Judge Vance intended to appoint had already been named in Michael's recording. Judge Vance did not hesitate. He appointed Grant Mercer, the same man whose name had been spoken weeks before Harold filed the lawsuit. Mercer arrived at Foster Maritime the next morning. He demanded access to the warehouse, bank records, employee files, customer contracts, and internal pricing. He also requested authority to discuss the possible sale of company property. Rachel told me to follow the written order exactly. Nothing more. I created an inventory of every document Mercer received. Every digital folder was logged. Every password change was recorded. Every download generated an access report. Harold later accused me of refusing cooperation. Rachel submitted Mercer's signed receipts and the system logs. The accusation collapsed. But Mercer had already gained access to the company's most sensitive information. 2 days later, our sales director called me. Harbor Ridge had contacted one of our largest customers. They offered the same delivery schedule Foster Maritime had created for the next quarter. The price was almost identical to our confidential rate. A second customer received a similar proposal that afternoon. Only a few people had access to both files. Michael was dead. I had not shared them. The sales team had not exported them. Grant Mercer had downloaded both customer folders less than 6 hours before Harbor Ridge began making offers. The receiver had not entered the company to protect it. He had opened the door for the buyer waiting outside. I had spent more than 20 years tracing supplies through complicated systems. When something disappeared, I did not begin with accusations. I began with time. Mercer accessed the first customer folder shortly after 8 in the morning. He exported the pricing sheet 12 minutes later. At 9:17, he downloaded the second customer contract. Before noon, Harbor Ridge contacted both companies. The proposals contained delivery windows, volume discounts, and service terms that had never been made public. Mercer called it due diligence, but no court order allowed him to share customer data with a potential buyer. Rachel requested the email records tied to his receiver account. The first response contained only selected messages. The forwarding history had been removed. Our system administrator recovered the server logs. They showed Mercer had sent an exported file to a Harbor Ridge advisor. The subject line read, "Operational exposure before acquisition." The attachment contained customer names, pricing, contract renewal dates, and delivery requirements. Rachel expanded the search. She found 3 earlier business cases handled by Judge Vance. In each one, the same pattern appeared. A company entered a family ownership dispute. Judge Vance appointed Grant Mercer. Mercer gained control of internal records. Customers or vendors began leaving. The company's value declined. Harbor Ridge, or an affiliated buyer, then acquired the assets at a reduced price. After each transaction, the consulting company owned by Judge Vance's brother received a payment. I mapped the process the way I would map a supply chain. Judge Vance created the legal access. Mercer collected the internal data. Harbor Ridge used it to weaken the company. The loss of customers lowered the value. Harold regained enough control to approve a sale. Peter earned his success fee. Harold paid his marina debt. The buyer acquired the warehouse and port rights below market value. Judge Vance's brother received a consulting payment. Everyone benefited except the company, its employees, and the lawful owners. Then Rachel found the full consulting agreement. The fee was not based only on whether Harbor Ridge completed the purchase. It was calculated partly from the difference between the company's independent value and the final acquisition price. The larger the discount, the larger the fee. That meant the system did not merely reward a quick sale. It rewarded damage. Every customer Mercer drove away made Foster Maritime easier to buy. Every contract Harbor Ridge copied reduced the price it might eventually pay. The people controlling the company stood to earn more money if they destroyed it faster. Rachel sent the new evidence to the State Judicial Conduct Commission. She did not make a public announcement. She did not threaten Judge Vance. She submitted a structured file. The first section contained Michael's voicemail, the carrier confirmation, and the forensic audio report. The second contained the courtroom transcript. It included Judge Vance calling my Navy Cross worthless. It included his refusal to recuse. It included his threat to hold me in contempt for playing an approved exhibit. The third section covered Grant Mercer, his appointment, his relationship with Harbor Ridge, the customer data exports, the recovered email, and the 3 earlier cases using the same pattern. The final section contained Judge Vance's communication log and his brother's consulting agreement. The commission issued an expanded preservation notice. It requested court email, telephone records, financial disclosures, receiver communications, and records connected to the earlier cases. Judge Vance received the notice. He still scheduled a hearing to approve the sale of Foster Maritime's warehouse. 2 days before that hearing, Peter offered a settlement. Harold would allow me to keep my home. I could retain my military retirement accounts. I could also keep part of Michael's personal investment portfolio. In return, I had to surrender my voting rights, give Harold control of Foster Maritime, withdraw every complaint, and agree never to release the recording publicly. Rachel placed the proposal on her desk. "They are offering you property that is already yours," she said. There was another problem. The judicial investigation no longer belonged to me. Michael had submitted the original evidence. The commission had opened its own file. I could cooperate. I could provide records. But I could not erase an official investigation because Harold wanted a private agreement. Rachel rejected the proposal. That was when Harold finally understood that winning the company would not protect him. Even if I disappeared, the audio remained. The emails remained. The access logs remained. Later that evening, Peter sent a revised settlement draft. He attached the wrong email chain. The messages discussed how my deployments should be described. One instructed Peter to call my capital contribution temporary family assistance. Another said Grant Mercer should receive full access before the ownership hearing. The final email came from Judge Vance's personal account. Once she looks theatrical, the Navy Cross becomes a liability, not an asset. The email had been sent 3 days before Judge Vance first saw me inside his courtroom. Judge Vance entered the courtroom on the morning of the warehouse hearing as though nothing had changed. Harold sat beside Peter with a transfer order already prepared. Grant Mercer had begun organizing customer files for Harbor Ridge. They believed the hearing would give them the final authority they needed. Then the chief administrative judge entered through the side door. Judge Vance stopped halfway to the bench. The administrative judge carried a written order. Judge Vance was temporarily removed from the case while his undisclosed relationships and communications were investigated. For several seconds, he did not move. Then he left without looking at me. The case was reassigned to Judge Rebecca Sloan. She did not begin with the recording. She began with ownership. Rachel presented the stock purchase agreement between Harold and Michael. The bank confirmed every payment. The stock ledger showed the completed transfer. The board minutes recorded Harold's resignation. His tax return described the money as proceeds from the sale of a business interest. His loan application stated under oath that he no longer controlled Foster Maritime. Harold claimed he had never understood the consequences of the agreement. His former attorney testified that Harold had been independently represented. He had negotiated the payment schedule himself. He had requested changes to the non-competition provision before signing. Judge Sloan then examined my ownership. Rachel presented the board resolution approving my capital contribution. The company's bank records showed the transfer from my personal account. The tax records described it as equity. The capitalization table listed my shares. Harold's own email called me a real equity partner. Judge Sloan upheld my voting rights. Then Rachel turned to the reason Harold had filed the lawsuit. She introduced the marina debt, the letter of intent with Harbor Ridge, the promised sale of the warehouse, Peter's success fee, the consulting agreement involving Judge Vance's brother. The agreement rewarded Harbor Ridge and the consulting company if the business was acquired below its independent value. Next came Grant Mercer. Rachel presented the voicemail in which Judge Vance named Mercer before the lawsuit existed. She presented the appointment order, the customer access logs, the exported files, the recovered emails sent to Harbor Ridge, and the proposals Harbor Ridge sent to our customers only hours later. Mercer called the disclosure ordinary due diligence. Judge Sloan asked him to identify the order authorizing him to share confidential customer data. He could not. The full recording was then played. The courtroom heard Judge Vance say, "Make the metal look like theater." Then his voice continued, "Once she loses credibility, Harold gets the company and Mercer gets the keys." Harold said he had never agreed to that plan. Rachel opened the email chain Peter had accidentally sent. It contained the strategy for describing my deployments. It contained the instruction to call my investment temporary assistance. And it showed Harold had been included in the conversation. Judge Sloan removed Mercer as receiver. His access to Foster Maritime was terminated immediately. The proposed warehouse sale was blocked. Harold's claim for control was denied. Michael's trust remained valid. My shares and voting rights were confirmed. The suspected data leak, false statements, and attempted diversion of company assets were referred for further review. Harold turned toward me. "That company carries my name." I looked at the stock agreement bearing his signature. "Your name built its beginning," I said. "Your signature sold your control. Michael and I kept it alive." Judge Sloan closed the file in front of her. Then she announced that 4 earlier business cases involving Judge Vance, Grant Mercer, and Harbor Ridge were being reopened. Judge Vance had not lost his career that morning, but every old ruling that had once protected him was beginning to speak against him. Judge Vance was first removed from probate and business disputes. The Judicial Conduct Commission requested his financial disclosures, personal emails, courthouse telephone logs, calendars, and communications with Peter, Harold, Mercer, and Harbor Ridge. Investigators also examined the earlier business cases. The structure was almost identical in each one. A family dispute placed a company in temporary uncertainty. Judge Vance appointed Grant Mercer. Mercer gained access to confidential operations. Customers, suppliers, or lenders were approached. The company's value fell. Harbor Ridge or an affiliated buyer acquired the assets at a reduced price. Judge Vance's brother's company received a consulting payment. None of those relationships appeared in the judge's disclosure forms. The investigation found more than social connections. Judge Vance had communicated with Peter outside the official court record. He had called him shortly after denying Rachel's motion to recuse. He had exchanged messages concerning the receiver hearing. His personal email had been used to discuss how my Navy Cross should be presented inside the courtroom. The commission compared that email with the recording and the transcript. His statement that the medal was worthless was not treated as the sole reason for discipline. A rude comment alone would not explain the destruction of a judicial career. The statement mattered because it matched a strategy he had discussed before the hearing. It demonstrated intentional bias. It showed that he had planned to damage my credibility before examining the ownership records. It also showed that he continued controlling the case after receiving formal notice that his relationships were under investigation. The formal charges included failure to disclose a family financial interest, refusal to recuse, improper communication outside the court record, misuse of a court-appointed receiver, conduct designed to benefit connected parties, and behavior that damaged public confidence in the judiciary. Judge Vance was suspended while the proceedings continued. Before the public disciplinary hearing, he announced his retirement. He described himself as a victim of political pressure. Retirement did not end the investigation. The commission published its findings. He lost the bench. He lost the authority that had made Harold and Peter believe the outcome could be controlled. His name remained attached to the decisions, emails, and calls he had tried to keep outside the record. Peter faced a professional disciplinary hearing. Grant Mercer was removed from the approved receiver list. Foster Maritime filed claims connected to the customer data breach. Harbor Ridge withdrew from the warehouse transaction and faced further civil review. Judge Vance's brother's company agreed to return disputed consulting payments. I did not speak to reporters. I did not stand outside the courthouse and celebrate. Losing his career did not bring Michael back. It did not erase the sound of Harold laughing when the medal was insulted, but it stopped the same pattern from being used against another family business. When the investigation ended, I returned to court one last time, not to watch Judge Vance lose anything else. To hear what would happen to Harold and to the company Michael had trusted me to protect. Judge Sloan entered the final order several months later. Harold had no controlling interest in Foster Maritime. The stock sale to Michael remained valid. My equity remained valid. Michael's trust remained in effect. I retained my voting rights and authority over his shares. Harold was ordered to pay a substantial portion of the legal expenses caused by his unsupported ownership claim. His affidavit and his role in the attempted warehouse transfer were referred for further review. The Harbor Ridge agreement collapsed. The warehouse remained with Foster Maritime. The marina debt did not disappear. Harold could no longer use Michael's company to rescue himself. He sold his vacation property. Then he sold his remaining interest in the failed marina project. I did not ask the court to punish him beyond what the evidence supported, but I did not withdraw the recording. I did not pay his creditors. I did not return management authority to him. And I did not defend Peter, Mercer, or Judge Vance from the consequences of their own records. They had each been given a chance to stop. They continued because they believed my silence meant I could be pushed aside. The damage to Foster Maritime took time to repair. 2 customers had nearly left. Employee confidence had fallen. Some contracts required new security protections. I did not walk into the warehouse and pretend military command made me an expert in every civilian operation. I kept the experienced management team. I hired an independent operations director. We strengthened access controls. We restored the employee retirement reserve. We protected the warehouse and the port contracts. More than 60 people kept their jobs. Then I returned to my duties with the Navy. Michael's old phone was sealed inside the evidence archive after the investigation ended. A forensic copy remained with the trust, the stock ledger, and the final court order. I did not keep it as a weapon. I kept it as proof. Months later, I attended a formal naval ceremony. I wore the same service dress uniform. The Navy Cross remained above my left pocket. It was not there to answer Harold. It was not there to challenge a judge who no longer had a courtroom. It was there because neither man had ever possessed the power to decide its worth. That evening, I visited the Foster Maritime warehouse. The company name was still above the entrance. Forklifts moved through the loading area. Trucks waited near the docks. The people Michael had fought to protect were still working. I entered his old office and placed the final ruling inside the safe. Beside it was a printed transcript from the first hearing. The words were still there. That medal is worthless in my courtroom. Below them was the ruling confirming my ownership and control of the company. I closed the safe. Through the office window, I saw the Navy Cross reflected faintly in the glass. Harold believed my silence meant I had nothing to say. Judge Vance believed one sentence could strip a medal of its meaning. They were both wrong. Discipline is not the absence of a response. It is knowing what to preserve, when to let the record grow, and when one verified voice can make every hidden agreement impossible to deny.